Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to talk about a recent piece of news that has the entire exosphere completely ablaze. And it is a very bragadocious tweet from Giffords, always a reliable news source, in relation to the pending votes on House Resolution 38. The tweet actually read, "New, major police orgs come out against the extremist concealed carry mandate, which would allow many to carry hidden, loaded guns nationwide without training or passing a background check. It's dangerous for police and the communities they are sworn to protect." So the question is that really true? Is law enforcement opposed to the passage of House Resolution 38? The answer is yes, they are, but it may be for reasons that have not truly been disclosed for you. So today what we're going to do is we're actually going to go through their opposition letter so we can answer this question, which is, are the cops really opposed to national carry reciprocity? Okay, America, we are talking about the intersection of law enforcement with a pending piece of legislation, which is House Resolution 38. House Resolution 38, the National Concealed Carry Reciprocity Act of 2025, would state, if enacted into law, that if you are carrying a firearm in some state other than yours, and you have photo identification, and you come from a state that offers concealed carry license, you have that in possession as well, then you are lawfully allowed to carry in that state that you are in. It would also say that if you come from a constitutional carry state, you will only actually need a piece of photo identification that proves that you are in fact a resident of that state. Does law enforcement have a beef with that? A little bit. The part, however, that law enforcement really has a beef, and what we're going to be talking about today is actually a letter from the International Association of Chiefs of Police, as well as the National Fraternal Order of Police. And I want you to understand something, America, that just because this is the official position taken of this organization does not necessarily mean that this is the belief that permeates throughout law enforcement. Much to what you see in labor unions sometimes. What the labor unions support politically versus what the labor members support politically oftentimes are different things. So to try to keep everyone calm and make sure that we're actually educating ourselves so that you can decide what does this truly mean, we're going to look at what's occurred here through 4 separate lenses, and they are as follows. Number 1, is law enforcement opposed to House Resolution 38? The answer to that question is yes. Number 2, is it based upon anti-Second Amendment positions? No, not primarily, but there is a little of that sprinkled into this opposition. 3, what is the beef really about? The beef is really about liability that would be injected upon law enforcement if this bill becomes legislation. And finally, will this kill the bill? No, because the bill is probably dead already. Okay, now what FOP and the IACP really have a beef with is this section right here in proposed House Resolution 38, which deals with potential liability for law enforcement who stop and investigate an armed individual. In particular, the language that concerns them the most reads, "A person who carries or possesses a concealed handgun in accordance with subsections A and B may not be arrested or otherwise detained for a violation of any law or any rule or regulation of a state or any political subdivision thereof related to the possession, transportation, or carrying of firearms unless there is probable cause to believe that the person is doing so in a manner not provided for by this section. Presentation of a facially valid document as specified in subsection A is prima facie evidence that the individual has a license or permit as required by this section." Okay, which means that presentation of a valid form of picture ID is prima facie proof that they are in compliance with the law. The bigger beef that both FOP and IACP has is a section in House Resolution 38 which reads, "A person who is deprived of any right, privilege, or immunity secured by this section under color of any statute, ordinance, regulation, custom, or usage of any state or any political subdivision thereof may bring an action in any appropriate court against any other person, including a state or political subdivision thereof, who causes the person to be subject to the deprivation for damages or other appropriate relief." So the focus of most of the objection from law enforcement here is those provisions, and they address it this way. This is problematic, but the most concerning provision of House Resolution 38 is that it prohibits law enforcement officers from making any arrest or detaining a suspect for any violation of state or local law pertaining to the possession, transportation, or carriage of a firearm. This also includes several federal laws, such as carriage in school zones and federally managed lands. That is not the purported intent of the statute. What it means is you could not arrest the person for merely possessing the firearm. Now, if there is something unlawful about the type of firearm they're possessing, or who they are, or where the firearm is currently being possessed, none of that is addressed in House Resolution 38. Now, law enforcement has additional concerns, which include: the bill goes further and provides that any person who is deprived of any right, privilege, or immunity may sue a law enforcement officer who would not be afforded qualified immunity. This makes it impossible for an officer to conduct any investigation with respect to ascertaining if the person is in fact compliant with the firearm law in their state of residence. It would also expose the officer to civil liability if, for example, they were to secure the firearm while they conducted an investigation into other suspected criminal activity. That last part is complete bunk, because under a case called Terry v. Ohio, we can, during a reasonable, articulable suspicion Terry-like stop, we can search for weapons. If weapons are discovered, we can actually temporarily detain those weapons, confiscate those weapons temporarily to ensure officer safety. The issue about being able to ascertain the lawfulness of the person's conduct, however, may be a legitimate concern, because I want you to consider this as an example. An individual from Texas who has absolute constitutional carry rights and is otherwise lawfully allowed to possess a firearm is now carrying in California, all right? However, when California Highway Patrol pulls him over and asks for identification, of course, the driver is able to present him with a valid Texas form of picture identification, presumably his driver's license. But so too would an individual who actually was a convicted felon from Texas be able to provide a similar looking piece of identification. And so what you're hearing from law enforcement is the existence of a firearm and a piece of picture ID or a CPL from some other state doesn't necessarily mean that the person is lawful. Now, that's their position. I'm not defending that position, but that is where they're coming from on this. Now, they have additional concerns, again, related to this portion of House Resolution 38, which includes: officers would be expected to interpret and apply laws from all 50 states in real time without reliable means to verify an individual's eligibility to carry concealed weapons, especially those from permitless carry states where no physical permit exists. This leaves law enforcement unable to confirm lawful possession during encounters, creating confusion and heightened risk in high-stakes situations. All of which may in fact be true, but all of that is based on this presumption that the existence of a firearm suggests criminal activity, when clearly the purpose of House Resolution 38 is that one would infer that it is legally possessed unless proven otherwise. Now, if you're a large organization representing officers on either a national or international level, you are abundantly aware, especially in the United States, of the privileges afforded through qualified immunity. And nothing is more sacred to law enforcement than qualified immunity. Therefore, any piece of legislation, even if the underlying purpose was completely agreeable to law enforcement, will never be supported when you, in fact, are threatening qualified immunity, as mentioned in this objection letter. The bill also seems to cancel any qualified immunity for the officer, as the right of Americans to bear arms is guaranteed by the Second Amendment. Qualified immunity protects officers from civil liability unless they violate clearly established statutory or constitutional rights. Any action the officer may take in reaction to the knowledge that the person they have encountered is armed could place that officer in very real legal peril. Okay. So I mentioned earlier that this is not necessarily an anti-2A position, but then I also said sort of, because unfortunately, both IACP as well as FOP also talks about, well, you're threatening state sovereignty, which translation is that we got states out there that are this close to absolutely abolishing Second Amendment rights whatsoever. But according to law enforcement, they seem to be okay with that, because they do, in this letter of concern, write the following: many states already recognize concealed carry permits from jurisdictions with comparable requirements, such as live training and enhanced background checks. These agreements respect state sovereignty and public safety without federal overreach. This legislation would override these tailored agreements and strip states of their ability to set and enforce their own standards for concealed carry. Yes, except that we have to acknowledge that there is a handful of states that would do anything humanly possible to ban all forms of concealed carry, and for out-of-state residents have virtually made it impossible. Okay, so just to recap where we are so far. Number 1, are they opposed to House Resolution 38? Yes. Number 2, is it based completely upon anti-Second Amendment positions? No, not completely on it. Number 3, what is the beef all about? Well, it's really about liability. And then, of course, the final question is will this kill the bill? The answer is no. And the reason the answer is no is because this bill is already DOA. Yes, it has a very good chance of passing out of the House of Representatives. That will be awesome. It will then go to the Senate, where it will need 60 votes. We do not have 60 votes. It will not get 60 votes. It's never going to make it out of the Senate. It's never going to be presented to the president. He's never going to get an opportunity to sign it. But realizing where law enforcement's main point of objection was, is there a workable version of legislation like this that could in fact get law enforcement on board? There may be. Now, I've already extended privately invites to representatives from IACP and FOP. If either of you would like to come onto the channel, we'll have a very open conversation about your position, why you took it here, and the explanations thereof. We would love to have that conversation with you. We're going to go ahead and link up the post. We're going to link up the letter. We'll link up everything we relied upon, including House Resolution 38, in making this video, so you don't have to take our word for it. You can geek out on it for yourself. Now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link and you tell us all about it. If you want to subscribe to the monthly newsletter, that link is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.